Brad Williams, Frugal Finance, one of the most important things every person needs in a file is, at a minimum, a will. It could be very simple, it could be complex, but you need to have a will acknowledged, recognized, and in a place that can be found upon your death. What happens in the event you don't have a will? Your assets will go to probate, then the courts, after a very long and costly probate. A judge will go, well, we'll make distributions here, then the state's going to take a huge chunk of it. Your inheritance will be cut pretty much to zip. The biggest mistake when it comes to will is not having one at all. Only a third of Americans currently have a will. I'm speaking to 63% of you that do not. It's even worse for those with kids. Only 28% of respondents with financially dependent kids have a will. If you're one of those Americans without a will, vow to make it happen. You can go online and just put will template. What happens if you don't have a will? If you don't have a will or any other kind of life plan, when you die, you'll become what's known in legal terms as intestate. And a court will go through an often lengthy legal process to determine your rightful heirs and a guardian for your minor children if you are the sole surviving parent. Each state has their own statutory will that decides who gets what when it comes to your assets. And of course, at this point, you have no say in it. All that said, some types of property, such as the assets of your employer-sponsored retirement plan or IRA, proceeds of a life insurance policy, and payable on death or transfer on death accounts, automatically pass to your named beneficiaries. Similarly, any financial accounts or real estate holdings that are titled as joint tenants with rights of survivorship generally will become the property of the joint owner. A will or living trust. When preparing your end-of-life plan, you will likely choose between a will and a living trust, or perhaps even both. American Bar Association has helpful FAQs that can help you understand these choices. Perhaps you can go online and you can go to NOLO, or you can just go online and get a template. If you need something very simple, a will, just do that. It'll take you 5 minutes. People don't like to talk about death. It is, quote unquote, it's creepy. Well, no, it's not creepy. It's reality. We all have to face it, so prepare. Get the document, acknowledge it, sign it, recognize who your heirs are, and just make note of it. Then if you want a living trust, you can pay an attorney or you can do it yourself. It's up to you. And there's enough stuff available. There are enough books. You can do it for less than $50. If you have a standard will, you, the grantor, designate an executor, someone who will have legal responsibility to carry out your will's instructions. That person will be responsible for filing your will with probate court, the court that deals in the administration of estates and managing your assets during the probate process. In some states, this process can be lengthy and might include fees. With a living trust, your heirs can often avoid having to go through the probate process to determine who gets what, because your assets will be transferred into the ownership of a trust. Instead of appointing an executor, you would appoint a successor trustee to head the trust after your passing. While you're alive, you can manage the property you put into the trust, and you can empower the trustee to manage the trust if you become incapacitated. Additionally, a living trust may provide more privacy. Typically, once a will enters a probate court, it becomes a public document. That means anyone can request to see it. A living trust is generally shielded from such requests except in cases of litigation. To hire an attorney or not, you're not required to hire a lawyer to draft a will, but it may be a good idea to ensure that the document is valid. Each state has a different requirement for valid wills. Some states may require 2 witnesses instead of 1, or they may require a will be notarized or filed with the court. Individual versus a joint will, you may think that sharing large assets with your spouse means you should have a joint will, but estates planning lawyers often recommend an individual will instead. Typically, a joint will bequeaths all of the couple's assets to the surviving spouse and then provides for all of those assets to go to the children upon the death of the second spouse, which seems in line with what many couples may want. However, most joint wills also contain a provision that neither spouse can change or revoke the will alone. That may cause problems for the surviving spouse down the line, as it may restrict the surviving spouse from selling the family home or any other assets covered by the will. Will there be anything left? Life is complicated, including death. And the last thing most of us want to do is leave our heirs a negative inheritance of debt. While many people imagine passing in their sleep at a very old age after they're carefully settled all their affairs, death is often unexpected. And the reality is many Americans don't prepare for retirement and unexpected expenses. More troubling, we are vulnerable to aging's cognitive declines, which for many can lead to impaired decision making. Here are a few steps to help build a positive legacy. Start an emergency fund. Almost half of U.S. adults have not set aside funds sufficient to cover expenses for 3 months in case of sickness, job loss, economic downturn, or other emergencies. Revisit your retirement. Only about half of Americans have tried to figure out their retirement savings needs. Here, check out my videos under retirement and look at the calculators. They're very simple, very straightforward, and you can experiment. You can play around with them. Prepare for the unexpected. Long-term retirement planning includes understanding beneficiaries, power of attorney, and living wills. Comment, let me know. Bottom line, by the end of the day, have some kind of draft of a will, anything. Put it on a napkin if you need to. I bequeath whatever to whomever. Sign it, put a date, put it in a file, then review it, or go online. Just do something. Create a will, create a living trust. Comment, let me know. Brad Williams, Frugal Finance. Thanks for watching. Hope that helped. See you soon.